Welcome to this hearing of the Judiciary Committee Subcommittee on Bankruptcy and the Courts. I'm pleased today to be joined by my ranking member, Senator Jeff Sessions. Senator Sessions has either been the chairman or ranking member of this subcommittee since 2001, with the brief exception of 2 years in the 111th Congress, during which time he served as ranking member of the full committee. His experience in overseeing the judiciary to ensure its efficient operation is unequaled, and I look forward to working with him as we continue that work together in this Congress. Broadly speaking, America's judiciary stands as a shining example of the genius of our founders. Vested with, quote, the judicial power of the United States, unquote, our federal courts act as a check upon executive or legislative overreach and as a neutral arbiter between parties in disputes. The limitations on government set by our Constitution, as well as the liberty interests reserved to the states and the people, ultimately rely on our judiciary to enforce them. When an individual is wronged or a business dispute arises, they can turn to our courts, get a fair hearing and a just resolution, and move forward with their lives. When the federal government seeks to deprive any American of life or liberty, it is the courts, and often the federal public defenders they employ, that make sure the government is forced to meet its burden of establishing guilt beyond a reasonable doubt. When the sequester was conceived, the across-the-board federal budget cut that it causes was thought to be so dangerous, so reckless, that it would force the Congress to responsibly confront our nation's spiraling deficits. Congress has not, however, acted, and the result has been an erosion of the ability of our government to do the people's business. I fear that continued, sustained, indiscriminate cuts to discretionary federal spending could push us to a point of crisis. The judiciary has looked at a variety of measures to address this new budgetary reality, and very few of them come without significant pain to the individuals, the litigants, the businesses, and others who rely on them. One proposal, to simply not schedule civil jury trials in the month of September, would effectively impose a 30-day uncertainty tax on every civil litigant before the federal courts. A judge in Nebraska has recently threatened to dismiss all so-called low-priority immigration status crimes because of a lack of capacity. In New York, deep furlough cuts to the public defender's office caused a delay of the criminal trial for Osama bin Laden's son-in-law and former al-Qaeda spokesman, Suleiman Abu Ghaith. In Delaware, my home state, the sequester has meant lengthy employee furloughs at the clerk's office of our bankruptcy court, resulting in reduced customer service hours and the postponement of infrastructure of IT upgrades that would aid the efficient resolution of those important cases. The cuts have not been deeper only because that office is already working with 40% fewer staff despite an increasing caseload, including many of the time-intensive mega cases important to our country's recovery. The Delaware Federal Public Defender's Office has had to furlough its defenders 15 days this year so far, essentially canceling the criminal docket every Friday for the rest of this year. Every day the public defenders are furloughed is another day defendants spend in pretrial incarceration at a cost to taxpayers of more than $100 a day. The Defender's Office has also had to sharply curtail expenditures for needed investigators and experts, which may be leading to a decrease in the quality of representation, leading to longer prison terms and more avoidable taxpayer expense. And if we don't act, frankly, the picture looking forward is still bleaker. Next year, the federal public defender's offices nationwide are scheduled to take a 23% budget cut. In Delaware, this means a third of the office would be laid off, but even that won't be enough. So the remaining employees would face between 26 and 60 furlough days, and funding for experts and investigation services would not be restored. 50 years ago this year, the U.S. Supreme Court gave substance to the Sixth Amendment's right to counsel in criminal cases when, in Gideon v. Wainwright, it ruled the government could not threaten indigent individuals with prison terms unless it also provided them with an attorney. The federal defender services are the embodiment of that vital legacy. The sequester is slowing the pace, increasing the cost, and potentially eroding the quality of the delivery of justice in our country. Congress's disappointing inability so far to responsibly replace the sequester and save the courts from these draconian cuts is eroding our fundamental constitutional rights. Individuals depend on the courts to be there when they need them, to seek relief from discrimination, to resolve complicated commercial disputes, and enable parties to stop fighting and get to work growing our economy. The irony is that cuts to the judicial branch that undermine its ability to do its job don't actually save taxpayers any money. The cases will still be adjudicated just at a slower pace and higher cost. The Constitution, as we all know, still guarantees the right to effective assistance of counsel, so courts will inevitably have to appoint a greater number of panel attorneys, who studies suggest do the job for 10 to 30 cents more on the dollar. Yes, our nation does find itself in fiscal crisis, and every branch of government must do its part. No one disputes that. The judiciary need not be exempted and is already working, as we will hear, to reduce expenses by selling or renting excess office space and canceling unnecessary training or conferences. Any expenses beyond core mission take a second priority and need to be looked at closely all across our government. That said, we're not going to be able to solve or even noticeably mitigate the national fiscal crisis on the backs of the courts, since they spend just 19 cents of every federal $100 spent. 19 cents for one whole branch of our government strikes me as a pretty good deal, particularly for a branch that does its job so well. In my view, the indiscriminate cuts of the sequester are truly penny-wise and pound-foolish. Dr. King once famously said, "Justice too long delayed is justice denied." I worry that by delaying the delivery of justice, the sequester may be denying it to too many Americans. I look forward to the testimony of our panel today, and I hope it will shed greater light on what the judiciary has done, what it would be forced to do if Congress continues to neglect its duty to responsibly replace the sequester.